Live from the drama-free true crime destination. No doubts, no delays, just the facts, the fire, and the finality that stands tall. This is the final word. And a good Friday evening, everybody. Welcome to the final word here on the drama-free true crime destination. Ernest Bethea, the last outlaw here. So good to have you with me on this good Friday evening. How appropriate is that? Okay, so tonight it's the calm before the storm. In this case, it's the calm before I bring you my dirty dozen on tomorrow night. I'll explain real quick. I'm bringing 12 of the cases I'm covering for this past week, and none of them are ever the same thing. Well, same thing as far as the intensity goes. More on that as we get to it. But tonight, it's the calm before the storm. I'm bringing other cases that I had covered for this week. So, without any further ado, let me bring the first story to you. We're going to go ahead and start this off out of Freehold, New Jersey. We're starting in Freehold, New Jersey, where convicted annihilation defendant Paul Canero now claims his guilty verdict was tainted, blaming the judge, not the evidence. What's happening is that Canero was convicted of murdering his brother, his sister-in-law, and their two children in the infamous Colts Neck Mansion killings, has filed a motion attacking the integrity of his own trial. His argument? The judge was hostile and frustrated and allegedly biased against him, creating an atmosphere that deprived him of a fair verdict. This comes after a years-long prosecution built on financial motive, arson evidence, and a timeline investigators said only Canero could fit. Here's the article itself, courtesy of our good friends at Court TV. A man convicted of murdering his brother, sister-in-law, niece, and nephew before setting fire to their home and his own home has filed an appeal blaming the judge and prosecutors for the jury's verdict. 59-year-old Canero was convicted of multiple charges, including 4 counts of first-degree murder and aggravated arson in the deaths of his brother, 50-year-old Keith Canero, Keith Canero's 45-year-old wife, Jennifer, and the couple's 2 children, 11-year-old Jesse and 8-year-old Sophia. Keith and Jennifer Canero were shot to death while the 2 young children were stabbed. Prosecutors say they were still alive when the house burned down. Burning down his brother's house, investigators say Paul Canero returned to his own house and set a fire there in an attempt to throw off investigators. Paul Canero's wife and daughters who were inside the home escaped. At trial, Paul Canero pleaded not guilty. His attorney argued that the police failed to investigate the case adequately and suggested that a third brother, Corey Canero, was behind the brutal killings. Now, in an appeal filed with the court, Paul Canero has pointed to the judge and prosecution's behavior as reasons for why he should get a new trial. Oh boy, my light's out. Give me a second. Gotta love this. It's got a short. All right, I'll just go on with light being out. Give me one moment. Okay, continuing on. Judge Mark Lemieux's frustration was visible beyond the stress ball mentioned during the trial. Canero's attorney said, beginning of the first day, he was often impatient, critical, and hostile toward the defense, and only the defense. Paul Canero's attorney Monica Mastaloni wrote, during a variety of sidebars, the court exhibited a clearly angry demeanor toward defense counsel, which was observable by the jury. Such demeanor included pointing at counsel, becoming flushed, scowling, squeezing a stress ball, and other angry gesticulations. On the third day of the quadruple murder trial, Lemieux joked that he brought in a stress ball to the courtroom. I picked a soft one, Lemieux quipped. I'm going to see how I do with this. You guys can keep an eye on me, see how I'm doing with this. But Mastaloni said that stress ball became a problem because it was used repeatedly when they were cross-examining witnesses or speaking at a sidebar. Because the court told the jury to keep an eye on his use of it, the jury was cognizant of the correlation between the stress ball and frustration of the defense. The brief includes an appendix of links to videos from various sources, including several from Court TV. The brief notes that Lemieux built a positive rapport with the jury panel, even having a joke or a question of the day to start each morning. The rapport was so positive, in fact, that Mastaloni noted juror number 9 even winked to the court as they left the courtroom. This rapport contrasts with the court's consistent negative treatment of the defense, undermined the patience and impartiality that the court must exhibit before a jury. Before the jury. Canero's attorneys also accused prosecutors of making improper statements in their closing arguments. Mastaloni said the prosecution inappropriately invoked religion and opined on the defendant's state of mind with comments like, and Paul's driving home, and he's got that voice in his head, right? He's thinking about that special bond with Jesse. He's thinking about, God, what did I just do with my niece? Do to my niece. Mastaloni also took issue with how the alleged murder weapon was characterized in closing arguments, especially when given a comment the prosecutor made about not owning any guns themselves while holding up the defendant's 6-hour firearm for the jury to see. The state said, "This thing's a beast." This inflammatory remark about a normal handgun, combined with the notion that the prosecutor in this case does not even own any guns, creates improper and prejudicial suggestions to the jury about how to consider this evidence. It was none of the jury's business whether the prosecutor owned any guns, nor was it proper for the prosecutor to characterize the handgun as a beast. Lemieux will hear arguments on the motion for a new trial at a hearing on April 20th. Canero faces life in prison when he is sentenced on May 12th. So given all those details, the defense strategy is saying that Canero's arguing the judge's tone and rulings created an unfair environment, pointing to moments where the court allegedly cut off questioning, limited arguments, or reprimanded counsel in front of jurors. The prosecutors maintained the evidence was overwhelming. The financial disputes between the brothers, surveillance and fire scene analysis, inconsistencies in Canero's statements, and the dual arson theory at Colt's Neck and his own home. They argued that the judge's conduct was appropriate and that Canero was simply attacking the process because the facts were devastating. What's at stake? A successful motion could mean a new trial, a reopened evidentiary hearing, or, more likely, a procedural denial that pushes the case toward appeals court review. This isn't just a legal maneuver. It's a convicted man trying to rewrite the story of a family wiped out in a blaze and a betrayal that stunned the Garden State, New Jersey. Honestly, I don't see Canero getting this appeal. I don't see Canero getting this new trial at all. In fact, if I were a betting man, I would actually lay down even money that come May 12th, what he's gonna get is life behind bars. But that's if I was a betting man. While I'm trying to get this before I go to the next story on our docket for this evening. All right, maybe I can keep my light on now. Good. All right, let's see. Well, what do we have next? Next up, Matthew Farwell. He's challenging the evidence of homicide in a push for bond. Yeah, he's challenging challenge of homicide in a push. So what's happening? Officer trying to break out of trial detention by attacking the very foundation of homicide of the homicide team. We are now in Boston. Matthew Farwell, charged with the young woman he met through a police-run youth program, is now challenging the government's evidence of homicide as he seeks release on bond. His legal team argues that prosecutors have not proven Birchmore was murdered and therefore have no basis to keep him locked up while awaiting trial. This is unfolding against the backdrop of a case defined by allegations of grooming, abuse of authority, and a death originally ruled a suicide. Let's dig in. After more than 18 months after he was arrested on charges that he killed his mistress and her unborn baby, a former Massachusetts police officer is fighting to be released from jail. 39-year-old Matthew Farwell is facing a federal charge of killing a witness/victim in the death of Sandra Birchmore. That charge was upgraded in 2025 to indicate that Birchmore was pregnant at the time of her death. Investigators have said that Farwell met Birchmore when he was 26 and working for the Staunton Police Department. At the time, Birchmore was only 15 and a member of Staunton Police Explorers Academy. Staunton Police Explorers Academy. Birchmore was found dead in her home in 2021. When Farwell was arrested in August of 2024, he consented to a voluntary order of detention without prejudice. Now, he's asking the judge to revisit the issue, saying he poses no threat to the community and should be released ahead of his trial. In a written motion opposing pretrial detention, Farwell's attorneys questioned the strength of the federal government's case, saying Sandra Birchmore's death by suicide was a tragedy, and the federal government's allegations that Mr. Farwell instead killed her are undoubtedly serious. Undersigned counsel expects, however, that much of what the government declaratively states is fact in its motion and accompanying affidavit are issues that will be heavily contested and litigated at trial. The motion says that Birchmore had a substantial and undocumented history of suicidal ideation, and on the day of her death, she used Google to search what color is the suicide ribbon. Farwell's attorneys also note that two forensic pathologists who looked at the case agreed that Birchmore killed herself. It wasn't until the government sought a third opinion from a third doctor, who, the motion notes, is not a forensic pathologist nor board certified in any specialty, that they were able to find someone classify the case as a homicide. Farwell's attorney notes that 2 months before his arrest, news headlines, including Court TV, suggested that he could face charges after prominent forensic pathologist Michael Baden said he thought Birchmore was killed. Mr. Farwell remains singularly focused on providing for his family and protecting them from the circus-like atmosphere generated in the wake of Ms. Birchmore's suicide and revelations surrounding his prior interactions with her, the motion says. While other men who had ongoing affairs with Miss Birchmore moved out of the state after her death, Mr. Farwell remained in the same home in the same town. While prosecutors have said Birchmore told Farwell that he was the father of her unborn child, recent DNA testing revealed that he was not. The other men mentioned in the defense motion include Farwell's brother and an unnamed individual who was confirmed to be the biological father of Birchwell's unborn child. Farwell's attorneys pointed to the extraordinary service to both his country and his community in the United States Army and his capacity as a police officer as reasons why he should be released. Farwell had been promoted to detective in the Stoughton Police Department before he was put on leave following Birchmore's death. He resigned in 2022 and later entered a voluntary decertification agreement. In the time since then, Farwell's attorneys say he took out a 10-year loan to start a business. To that end, he obtained a commercial driver's license and bought a semi-truck and trailer. Farwell's attorneys have proposed that he be released on a $50,000 bond with strict conditions that would include house arrest at his mother's home. No hearing has been scheduled on that motion. So here's the details. Farwell's attorneys are pushing for a simple but aggressive argument. If the state can't definitely prove homicide, then Farwell shouldn't be held as if one occurred. They're framing the death as ambiguous, suggesting suicide or accidental death remain plausible. The prosecution say the evidence is clear. Birchmore was pregnant. Farwell had motive tied to exposure and reputation. The scene was allegedly staged, and digital and communication records point to manipulation and control. They argue that Farwell was both a danger and a flight risk, especially given the severity of the charges and the potential sentence. This isn't just about Bond, though. It's a story about the death itself. Farwell wants the court to see uncertainty. The prosecution, however, wants the court to see a pattern of predation culminating in homicide. A bond ruling here will signal how the court views the strength of the homicide evidence. If the judge denies bond, it reinforces the prosecution's narrative. If it's granted, it suggests the defense has successfully introduced doubt at a critical early stage. A vulnerable victim, a death long mislabeled, and a community still grappling with how a police run program became the gateway to exploitation. Farwell's bond challenge is not just procedural, it's an attempt to reshape the narrative before the trial. And right now, it looks like things could go in Farwell's favor if they were able to push this forward and say, yeah, this is the way this exactly happened. And not only should this man be released on bail, they may go ahead and push to drop the charges totally. But that remains to be seen. Next up, one for the Justice Serve file. A man is sentenced for killing his girlfriend in Michigan before fleeing to Vegas. A Michigan man who murdered his girlfriend and tried to outrun justice across state lines has now been sentenced. This now closes a case defined by violence, flight, and inevitable capture. Maybe we'll get to sentencing before I break down everything. Ah, okay. We're gonna try to this courtesy of Court TV on YouTube. So we're gonna try to stretch this thing as best we can. So here we go. I am going to take myself out the shot. Oh, never mind. I'm not even in the shot. Okay, so what I'm gonna do is mute myself, and the next thing you're gonna hear is the sentencing for this man. This man, Randall Grinwis.
Right, we are on record now, and you may call the next file, Mr. Madden.
Thank you, Your Honor. This is People versus Randall Allen Grinwis, file 24-046680-FC. Date and time set for sentencing. The defendant appears in person from the Outlaw County Jail with his attorney, Mr. Silsky.
All right, and Mr. Silsky, you're present, and your client has also been brought into court, correct?
Yes, Your Honor, he's here.
Right, and let's take care of the SIR completion first. Court has received the People Sentencing Memorandum as well as Defendant Sentencing Memorandum, and that had the details set out. So we'll go over the offense variables. OB3 was scored at 50, I believe. Both attorneys are in agreement that that should be 25. Is that correct?
That is correct.
Yes, Your Honor, that's correct.
Right, and then in regard to OB5, so that OB3 will be made 25 points then. OB5 is currently scored at 15. Is that correct with your calculation, Mr. Manama?
Yes.
As well as yours, Mr. Silsky?
Yes, Your Honor.
All right, then we'll move to OB6. That's scored currently at 10. Mr. Madama, you were making a request for 25 points. Mr. Silsky is opposed to that. You may go ahead with your request, Mr. Madama.
Thank you, Your Honor. Offense variable 6 should be scored at 25 points. 10 points as currently in the PSI is more appropriate if the jury had found the defendant guilty of manslaughter. The sentencing guidelines manual essentially mirrors 10 points for a manslaughter conviction. 25 points is essentially mirrored in the second-degree murder conviction that was handed down by the jury. So offense variable 6 should certainly be 25 points.
All right, Mr. Silsky, what's your position in regard to that?
Your Honor, our position is that the agent correctly scored offense variable 6 at 10 points.
All right, so for 10 points, it would be based on there was gross negligence amounting to an unreasonable amounting to an unreasonable amount or unreasonable disregard for life. 25 points reads as follows. The offender had unpremeditated intent to kill, had the intent to do great bodily harm, or created a very high risk of death or great, knowing that death or great bodily harm was a probable result. The court is finding that 25 points is appropriate for the creating a very high risk of death or great bodily harm, knowing that death or great bodily harm was a probable result. We had testimony that the defendant was trained in CPR, and the court is finding that based on his behavior, on the defendant's behavior, then he did create that high risk of death or great bodily harm, and he knew that was a probable result or a likely result. And so the court is finding that for OB6, that 25 points is more appropriate, so 25 points will be scored there.
Thank you.
So now we may move to OB10. You are asking for 5 points there, Mr. Manama. You may go ahead with that argument.
Thank you. Offense variable 10 is properly scored at 5 points when the offender exploited the victim by his or her difference in size or strength, or both. or exploited a victim who was intoxicated under the influence of drugs, asleep, or unconscious. This court had heard evidence presented at trial in the manner that multiple times the defendant said the victim did not fight back or move because of the differences between his size and her size, and because she was intoxicated and had taken her medications. So offense variable 10 is properly scored at 5 points.
All right, and Mr. Silsky, what's your position in regard to OV10?
Again, Your Honor, our position is that the writer of the PSI report correctly scored it at 0 points.
The court is agreeing with Mr. Madama at this time because of the size difference. There was testimony that there was 100 pounds of size difference between the victim as well as the defendant. So that size difference, and there's also plenty of testimony throughout the trial that the victim was also intoxicated. All right, so OV10 will be scored at 5 points. And the only other thing that was scored was in regard to OV19. I believe both attorneys agree that OV19 should be scored at 0 points. Is that correct?
That's correct.
Yes, Your Honor, that's correct.
All right, thank you. So then the total points is for 70 points on the offense variable, which keeps it in the same range, the same point level, and the guideline minimum range does not get changed either. The guideline minimum range is 180 months to 600 months. That's in regard to the minimum guideline range. All right, did you have anything that you wanted to add at all to the PSI, Mr. Madama?
No other additions to the PSI, Your Honor.
Anything else in regard to the PSI, Mr. Silsky?
Your Honor, I believe that we should briefly discuss the guideline scoring for the count 2 for the larceny over $1,000.
Yes, we can go ahead with that.
Your Honor, on that, once again, offense variable 19 was scored at 10 points, and I believe the correct score would be 0 there. The offense variable total would be 5 points, and the PRV level would not change, but the guideline range for C1 is 0 to 18 months.
All right, what's your position in regard to that, Mr. Madama?
I concur with that, Your Honor. Thank you.
The court also concurs with that, so the guideline minimum range will be 0 to 18, and the OV19 will be scored at 0 points. You. So, Mr. Madama, do you have anybody here who wishes to make a statement?
I do, Your Honor. Lisa Vanderyacht is the representative of the victim, Donna's daughter, would like to address it.
You may come forward. Come right up to the corner. There's a microphone on the very end of that corner. And so stand right by there and go ahead and state your full name first of all.
Lisa Marie Gertrude Vanderyacht.
And go ahead and spell your last name.
Vanderyacht.
And what's your relationship to the victim here?
She's my mom.
Thank you. You may go ahead with your statement. And just keep your voice up because it all is being recorded. Thank you.
Your Honor, my mother was murdered by Randy Grinwas. He was not a stranger, he was family. We let him in. We trusted him. For 20 years, he was one of us. And in return, he stole my mother. I want the court to understand something about who she was to him. She was the only thing keeping him on the straight and narrow. Without her, he had no structure. He was unable or unwilling to have self-discipline on his own. They were in a race to the bottom long before she died. And now that she's gone, he has nothing. No structure, no discipline, no one to hold him accountable. What does he have to offer society? I also want the court to understand that I gave him the blueprint. My mother and I had a rocky past. She was difficult. I know that. But I told him how to build a respectful relationship with her. I gave him the answers. I showed him what the work looked like. And instead of putting in that work, he ignored it. He had the answers. He knew what to do, and he decided it wasn't worth it. He chose every day not to do the work. And then one day he snapped and took her life. Let me be clear about what he meant by snap. In his own words, it was a day just like any other. Yeah, they were fighting, that was normal. But she wasn't being extra mean. Nothing about that day was different. He just snapped. In ordinary fight, and he decided to end her life. I want the court to remember something else he said. after he took her life, he said that if he had won in Vegas, he would have kept going. He didn't stop because he was sorry. He stopped because he ran out of money. It doesn't sound like a man with a guilty conscience. It sounds like a man with a hungry stomach. It's not a man who made a mistake. It's a man who had the tools, had the instruction, had the support, and chose to let it rock. He knew what to do. He knew how to be better. And he decided she wasn't worth it. It's not somebody who belongs in society. He broke our trust. He stole my mother. She never got to meet her great-grandkids. She never got to pay off her own house. She never got to grow old. And I had to go through everything that came after. The grief, the confusion, the paperwork, the questions I'll never get to ask her without the one person I could always turn to. He stole that from me. And why? Because she was mean to him? Because his feelings were hurt? If somebody's treating you badly, you leave. You don't stay. You don't take their life. He had a perfectly fine house right across the street, but he wanted hers. And she wanted safety. And because of his actions, neither of them got what they wanted. I lost 2 people that day. My mother and the man I thought I knew for 20 years. I didn't realize how complicated losing somebody in that way would feel. I trusted him. We all trusted him. And he took the one thing you can never replace. Your mother. You only get one. She's gone now. Gone because he didn't want to do the work. I trusted him with her life, and now I have to live with that for the rest of mine. The best I can hope for at this point is knowledge that he won't be able to do it to anyone else.
All right, thank you for sharing that. It's very meaningful. Thank you. All right, do you have anyone else here to make statements?
No, Your Honor, I do have elocution.
You may go ahead with that.
Thank you. Your Honor, I couldn't say it much better than Lisa did. I expect that you'll probably hear that he walked into that Las Vegas police station because he just couldn't take it anymore and had that guilty conscience. That's not what the evidence bears out. He fled to Vegas. He extended his stay at his hotel. He even outright said to Ottawa County Sheriff's Department investigators, I would have kept running if I wouldn't have lost that money. If I would have hit when I gambled, I would have kept running. He walked into that police station not because of a guilty conscience, but because out of necessity. He was homeless in Las Vegas and had nothing, no other choices. We can't look past the way that Donna either. This was not, he says he snapped. He said over and over, I snapped. This was not a snap. 2 of the people's witnesses said this would have taken minutes, but even by the defendant's own expert, she said it would have taken at least 40 seconds. At trial in this matter, if you remember, I held up my phone and played 40 seconds and how long that was. He had 40 seconds to change his mind, and instead he continued pressing down on her. So that also cannot be overlooked. I was a bit surprised by the recommendation in the PSI, given the guidelines that he has, even with that 10-year gap. The way he did it, what he did afterwards, Your Honor, he has earned himself a sentence at or near the very top of those guidelines. Thank you.
All right, thank you. All right, and Mr. Silsky, do you have anything else, Mr. Meadow?
I do not hear him.
All right, thank you. So, Mr. Silsky, do you have any corrections or anything in regard to the PSI yet?
None other than the questions we had on the scoring of the offense variables, Your Honor.
All right, so those have been dealt with?
Yes.
And what would you like to state on your client's behalf?
Thank you, Your Honor. I think unsurprisingly, I'm saying that he was motivated by grief at the time when he turned himself in to the Las Vegas Metropolitan Police Department, when there was no warrant outstanding, when the investigation wasn't moving, as far as we know. All of the information that he provided was the glue for the timeline that the prosecutor presented to the jury. Going to the casino, going to Chicago, going to Vegas. The police didn't have any of that information. They only started looking for that once they had the report from the Las Vegas interview with the detective out there, in which Mr. Grinwis fully accounted for what had happened. Was he desperate at that point because of having no money? Undoubtedly. But he didn't have to turn himself in to the police in order to find a place to stay. They have homeless shelters in Las Vegas. He didn't have to confess in order to get a meal. In fact, there's no indication that when he was at the police department that he was asking for food or anything other than the opportunity to talk to the police. So I say that that shows he was motivated primarily by his grief. It took him a while to realize it, to realize the magnitude. I don't think that's unusual. So we would ask the court to consider minimum sentence near the lower end of the guideline range. Thank you.
All right, thank you. Right, so, Mr. Grinwis, I'm going to ask you to state your full name, please.
Randall Allen Grinwis.
And have you had an opportunity to read through the pre-sentence investigation report?
Yes, ma'am.
And do you have any corrections to this report, the pre-sentence investigation report?
No.
And is there anything you want to say before sentence?
No, ma'am.
Right, thank you. As the court has read through the pre-sentence investigation report, this is a very sad situation and sad case. This was an incident that could have been totally avoidable. You had options. You could have left the place where you were living with her. You had other options, but you chose to do a very drastic and very evil option. So in regard to sentence here, the court is going to sentence you now in regard to the two counts, the one count for homicide second degree, or murder second degree, and then the count two for larceny of $1,000 or more. In regard to the count one for the homicide, you must pay restitution in a total amount of $5,445. $3,645 is for funeral expenses to Lisa Vanderwall. And $1,800 is for Randy Barton because you took his money. You must pay a state cost fee and a crime victim assessment fee. The court is going to waive the other costs and fines and your attorney fee. In regard to count one, the sentencing memorandum had a recommendation from the people, and it also had a request from the defense. And of course, they're at opposite ends. The prosecutor is asking for the high end, the defendant is asking for the low end. So the court is going to do the following. In regard to count one, the court is going to go to the middle of the guideline range, and that is for 32.5 years. In the Michigan Department of Corrections on the minimum end. You are sentenced to the Michigan Department of Corrections for a period of not less than 32.5 years to a maximum of 90 years. That in months is for 390 months on the minimum end to 1,080 months on the maximum. In regard to the count two for larceny, the habitual fourth there, the court is sentencing you there for 365 days. The guideline range was 0 to 18 months. The sentence is for 365 days on the count 2, with credit for 365 days already served. And the guideline range, or the PSI, calculates that you have 805 days of credit for jail time. So in regard to count 1, you have 805 days of credit. This is the final sentence of the court. So you will get some paperwork now in regard to your ability to appeal to the Court of Appeals, both your conviction and your sentence. If you wish to ask for a court-appointed attorney, you may do so. One will be appointed for you at public expense. You have 42 days to fill out the form and turn that in if you want an attorney for an appeal. Do you have any questions at all?
No.
Right. Good luck to you. We're adjourned. Defendants remanded. Thank you.
Thank you, Eric.
Unbelievable. I went Grand Haven, Michigan. A man was sentenced to spend at least 3 decades behind bars after a jury convicted him of brutally murdering his girlfriend. 59-year-old Randall Grinwis was found guilty of second-degree homicide and larceny of between $1,000 and $20,000 following a jury trial last month. On Monday, he returned to court to face Judge Karen Miedema, if I'm pronouncing her name correctly, for sentencing. Grinwis had pleaded not guilty in the death of Donna Heimer, 63-year-old whose body was found in the home the couple shared on January 1st, 2024. The Holland Sentinel reported this. At trial, prosecutors said that Grinwis used his forearm to choke the victim before stealing money from her brother and taking off for Vegas. Grinwis's attorney, Philip Selesky, told the judge his client was motivated by grief when he turned himself in to the Las Vegas Metro Police Department following Heimer's death, as you just heard. He noted at the time Grinwis went to the police, there was no warrant out for his arrest. All the information that Grinwis provided was the glue for the timeline that the prosecution presented to the jury. Selesky said as he asked Medema to sentence the defendant to the lower end of the sentencing guideline. But Heimer's daughter, Lisa Vanderyacht, characterized Grinwis's behavior very differently in a victim impact statement she delivered to the court. He said if he had won in Vegas, he would have kept going. But he didn't stop because he was sorry. He stopped because he ran out of money. It doesn't sound like a man with a guilty conscience. It sounds like a man with a hungry stomach. He had a perfectly fine house right across the street, but he wanted hers. And she wanted safety because his actions, neither of them got what they wanted. In discussing Heimer's death, Grinwis repeatedly told officers that he snapped. The prosecutors and Vanderyacht told the judge that the evidence told a different story. The defense's own expert at trial testified that it took at least 40 seconds for the victim to die. He had 40 seconds to change his mind, prosecutors said on Monday, as they urged Miedema to sentence him to the maximum. Miedema elected to compromise and sentence Grinwis to 32.5 to 90 years in prison. Grinwis stood mostly silent at the hearing, speaking only when asked to confirm his name by the judge and declining an opportunity to address the court. Wow. So that sentence was that it reflected the brutality of the killing, the attempt to evade justice, and the danger he posed to the public. The judge emphasized accountability and the seriousness of fleeing after committing a violent crime. Give me one moment. The judge emphasized accountability and the seriousness of fleeing after committing a violent crime. This case now sits at the intersection of intimate partner violence, interstate law enforcement coordination, and the myth of getting away by running. It's a reminder that homicide investigations don't stop at state borders, and flight often becomes the part of the narrative that will seal a defendant's fate. And my commentary before I end on that article, Johnny Cash said it best. You can run on for a long time, but sooner or later, God will cut you down. In this case, it was God because of a guilty conscience. So now, 32 and a half to 90 years behind bars, and he's how old? Justice served. Next up, this one kind of got grabbed my attention here. Joseph Duggar, remember him? He was one of the 19 kids in the on the TLC series 19 Kids and Counting. Well, he gets a $600,000 bond in a Florida molestation case. A Florida judge has set a $600,000 bond for Joseph Duggar, who is charged with molesting a minor, a ruling that immediately raised questions about risk, access, and accountability. Here's the breakdown before the article. Joseph Duggar appeared in a Florida courtroom where a judge set his bond at $600,000 in a molestation case involving a minor. Prosecutors argued that he poses a danger to the community and should have remained behind bars. The defense pushed for release, saying Duggar has strong ties to the area and can comply with strict conditions. The judge ultimately landed on a high-dollar bond with multiple restrictions. We'll break all that down in just a moment. But here's what we got courtesy of Court TV from Panama. Reality television's Joseph Duggar appeared before a Florida judge on Tuesday morning on charges alleging he inappropriately touched a young girl. The 31-year-old appeared remotely from the Bay Area jail, wearing a striped jail uniform and holding a sheet of paper. He pleaded not guilty to a charge of lewd and lascivious behavior and a charge of lewd and lascivious molestation. Joseph Duggar signed a form indicating he did not want a public defender appointed for him. Attorney Albert Soline, who appeared on his behalf in court, requested a reasonable bond, saying that his client has no prior criminal history. He asked to be treated as fairly as anyone else, regardless of his status in the television industry, noting that Joseph Duggar's father had come to town to post bail. Joseph Duggar and his large family formerly starred on the TLC reality show 19 Kids and Counting, which followed their lives. The show was canceled in 2015 after Joseph Duggar's brother Josh was accused of molestation 4 of his sisters and a babysitter. Josh was convicted in 2021 and is serving a 12-and-a-half-year prison sentence. In the current case, prosecutors say Joseph Duggar touched a 9-year-old girl inappropriately while on vacation with family in Panama City, Florida. The alleged victim told the police that Joseph Duggar touched her over her underwear while sitting next to her beneath a blanket on a couch. When the alleged victim's father confronted Joseph Duggar, police say the defendant admitted his actions, stating he touched the victim over her clothing. The defendant admitted his intentions were not pure. Judge Tracy Smith set a total bond of $600,000 in the case and ordered the defendant to have no contact with the alleged victim and no unsupervised contact with any minors. Joseph Duggar and his wife Kendra are also facing unrelated charges in Arkansas. There, they are each charged with 4 counts of endangering the welfare of a minor and 4 counts of false imprisonment. Joseph Duggar was arrested on the Florida charges at his Arkansas home and then waived extradition to the Sunshine State. Joseph Duggar is scheduled to return to court in his Florida case on April 20th. And as a side note, it has been reported that Joseph and Kendra Duggar's children had been taken away from him because of those charges. Here's all the details. Duggar's accused of molesting a minor, a charge that carries severe penalties and immediate public safety concerns. Prosecutors emphasize the seriousness of the allegations and the vulnerability of the victim. While the prosecutors push for no bond, the courtroom debate centered on the risks to the community, potential access to minors, flight risk, and the nature of the allegations. The defense argued that Duggar has family support, employment history, and no prior failures to appear. So, the judge, as I mentioned, set the bond at $600,000 because the allegations are grave. Duggar is not being released lightly, but the court is allowing a path to pretrial freedom under strict supervision, which could include GPS monitoring, no contact with minors, as we already know, no contact with the alleged victim, that we also know, surrender of his passport, and restricted his movement. Those are possibilities as well. Cases involving alleged sexual abuse of minors always carried heightened scrutiny. Bond decisions become a balancing act between the constitutional rights, community safety, and the emotional weight of the allegations. This ruling reflects a court trying to thread that needle high enough to reflect danger, but not a de facto denial. So, the thing here is, if Joseph Duggar is trying to follow in any member of his family's footsteps, he's well on his way to following his brother Josh. And next thing you know, we'll be talking about him doing time behind bars. Next up, Tiger Woods. He told deputies after his Florida DUI crash, quote, "I took a few," end quote. Newly released documents showed Tiger Woods admitting to deputies that he had, quote, "taken a few" before his Florida crash. That's a detail that reframes the investigation and the public narrative around the incident. Documents from the sheriff's office revealed that when deputies reached Tiger Woods after his Florida crash, he told them, "I took a few." Took a few what? The statement appears in the official reports tied to the investigation, adding a new layer to a case that has long been scrutinized for what caused the crash and what Woods' condition was at the time. Now, this isn't the first time Woods' driving incidents have raised questions about impairment, medication, or physical condition, but this is the first time this specific admission has surfaced in the record. We're in Stuart, Florida, where newly released police documents indicate that officers found drugs in golf legend Tiger Woods' pocket after he crashed his car while driving last week. 50-year-old Woods is charged with DUI, damage to property, and refusal to submit to DUI testing following the March 27th crash on Jupiter Island. He has pleaded not guilty to the charges and released from custody after his arrest on March 27th. In an arrest affidavit released by the Martin County Sheriff's Office, deputies said that Woods was driving his black Land Rover SUV behind a white Ford F-150 pulling a trailer. When the F-150 slowed to turn right in a driveway, Woods allegedly attempted to go around the truck by crossing the double solid line into oncoming traffic. Deputies say Woods clipped the truck, causing him to lose control of his vehicle and flip it onto the driver's side. The other driver was not hurt, and Woods denied having any injuries at the scene. When officers arrived, they observed Woods sweating profusely and described his movements as lethargic and slow. When they asked him how the crash happened, Woods allegedly said that he had been looking down at his cell phone and changing the radio station and failed to notice the truck slowing down in front of him. Deputies asked Woods to remove the sunglasses he was wearing and noted that his eyes appeared bloodshot and glassy beneath them. Woods allegedly denied having any alcohol that day, but when asked if he took any medications, he said, "I took a few." Woods told investigators that he takes medicines for high blood pressure and cholesterol, as well as ibuprofen and Vicodin for pain, according to investigative reports reviewed by Court TV. When given a breathalyzer, Woods' blood alcohol levels were shown to be 0.00, but other sobriety tests officers administered had a different result. When Woods was asked to move his hands in different ways and count in other tests, officers said he had trouble following the instructions. He refused to take a urine test when asked. Officers who searched Woods reported finding 2 pills in his pants that they identified as hydrocodone, the prescription opioid commonly found known as Vicodin. Again, this isn't the first time that Woods has crashed a car. In 2023, a golfer was found unconscious after crashing an SUV into a raised median in Southern California. In that case, investigators said that there was no sign of impairment and blamed excessive speed for the crash. In 2009, Woods was cited for careless driving after running over a fire hydrant and hitting a tree on the morning after Thanksgiving in Florida. In 2017, he was arrested on a DUI charge after police found him asleep behind the wheel of a parked car on the side of the road in Florida. Woods is due to return to court for his arraignment on April 23rd. Ay, vey. Let's see, the crash. Let's see, the crash. The deputies responded to a single vehicle crash involving Woods, who was found the vehicle had sustained required medical attention. According to documents, Woods told deputies, "I took a few." The report does not specify what he meant, medication, pain pills, or something else, but the phrasing immediately became a focal point of the newly released records. As far as medical history, we know Woods has a well-documented history of back surgeries, prescribed pain medications, prior driving incidents involving impairment concerns. Investigators reviewed toxicology, medical records, and crash scene evidence to determine whether impairment played a role. And right in the legal outcome, despite that statement, Woods wasn't charged with DUI. But officials cited lack of probable cause, absence of clear signs of impairment, medical explanations for his condition. The crash was ultimately treated as an accident, not necessarily a criminal case. Any incident involving Woods carries outsized attention. This new detail doesn't reopen the case, but it does reshape public understanding of what deputies encountered that day and how close the situation came to becoming something more serious legally. All I can say to that is, as far as Tiger's driving and medical prescriptions, or whatever the case may be, Tiger, if you're gonna drive, leave those pills behind. If you're gonna take the pills, do not get behind the wheel. That's only common sense. Because the last thing I want to end up saying, and as a fan of yours, Oh, how the mighty have fallen. Just saying. Okay, next up. This one might go into my new funny file for this. A prosecutor is apologizing for for fictitious cases cited by AI in a Supreme Court brief. Yeah, you heard that one right. A state prosecutor is now apologizing after discovering that multiple cases cited in a Supreme Court brief were completely fabricated, generated by artificial intelligence, and never checked before filing. Here's what happened. A prosecutor has issued a formal apology after submitting a brief to a state Supreme Court that relied on fictitious legal citations created by an artificial intelligence tool. The cases looked real, sounded real, and were presented as precedent, but none of them existed. The error was caught during review, forcing the prosecutor to publicly acknowledge the mistake and correct the record. This incident lands squarely in the growing national conversation about the risks of unverified AI use in the legal system. I will reserve my commentary on that after this article. We're in Atlanta, where a Georgia prosecutor has offered a formal apology after she says she used artificial intelligence when she submitted briefs to the court and cited cases that don't exist. Assistant District Attorney Deborah Leslie filed a supplemental brief with the Georgia Supreme Court after appearing before the court to deliver oral arguments in the case of Hannah Payne. Payne, who was convicted of murder and other charges in the death of another driver, has appealed her conviction and claimed ineffective assistance of counsel. But when Leslie appeared before the court on March 20th, the justice questioned several citations that appeared in both her brief and the lower court's order denying Payne a new trial. These errors were not intentional, Leslie wrote in the newest brief filed on last Friday. Leslie wrote that she used traditional and AI research tools when she prepared both her briefs in Payne's case and the proposed order that the trial court later signed denying the motion for a new trial. Leslie said she intended to provide a more detailed explanation of the relevant legal principles, but conceded that case references generated by AI were not independently verified before inclusion. Despite the fictitious cases and erroneous citations, Leslie said the meaning behind her briefs remains unchanged. The undersigned has carefully considered whether and to what extent these erroneous citations affected the substance of the state's arguments or the trial court's ruling. Leslie wrote in an affidavit attached to the brief. To the best of my understanding and belief, the legal positions advanced by the state did not depend solely on the fictitious or misattributed authorities, but were supported by valid precedent and the trial record. I fully acknowledge, however, that the inclusion of any inaccurate citation is a serious matter. To prevent a similar slip up in the future, Leslie said she has implemented several safeguards, including requiring all case citations to be independently verified, a dedicated citation verification step in the drafting process, and a second level review of citations by another attorney or qualified staff member. Leslie continued to say, I assume full responsibility for the inclusion of the erroneous citations. I reaffirm my unwavering commitment to the standards of candor, accuracy, and diligence that the court properly expects the officers of the court. Payne is serving a life sentence plus 13 years for her conviction, but maintains that her attorney failed to adequately research the law. The Georgia Supreme Court said it would issue a ruling on her request for a new trial, but offered no time frame as to when it might publish its opinion. Wow. Look, I mean, I'm no lawyer myself, but even I know that AI, one, is not perfect, and two, can get it wrong. The filing error. The prosecutor used an AI system to help draft a part of a legal brief. The tool generated case names, docket numbers, legal holdings, quotations, all of which were fictional. The prosecutor admitted that they did not independently verify the citations before submitting the brief. The Supreme Court flagged the citations during the routine interview. Once the cases couldn't be located in any database, the court demanded clarification. That triggered the prosecutor's investigation and the eventual apology. The prosecutor had acknowledged that the citations were fabricated, the responsibility was hers alone, and the court was misled, even if unintentional. The case highlights a growing tension in the legal world that because the AI can draft quickly, but it can also hallucinate, wink wink, inventing facts, cases, or legal principles. Courts across the country have already begun issuing warnings and requiring certifications that filings are human verified. Ladies and gentlemen, this is not just a clerical mistake. This is the kind of thing that touches on the integrity of legal filings, the credibility of prosecutors, and the reliability of artificial intelligence in high-stakes environment, and the responsibility of the attorneys to verify every word they submit. In a system built on precedent, citing cases that never existed is more than embarrassing. It undermines the foundation of the argument itself. So this is what I want to say about that. If you're going to use AI to help draft your legal brief, attorneys, talking to you, there is a good 100% chance that if you submit this, you will be submitting some poor, misjudged, misled, mismanaged misinformation. And that for you being an attorney is the last thing you personally would not want to have happen. And on top of that, the last thing you would want to do at that juncture is to be issuing a mea culpa. Next up, Kevin Ellis admits I should have said no in a jail call played at sentencing. A jailhouse phone call became the emotional centerpiece of Kevin Ellis' sentencing, with Ellis himself argued to sum up the entire case. No.
Can determine your sister from having to go back to California to complete a divorce. Yet you could have stopped your actions at any time, as I mentioned, and let that procedure follow through in the civil courts. As Mr. Williams properly noted, but I do think it's important to always mention, family of a victim. I set parameters. We have a sentencing system in the state of Utah. The Utah State Parole Board will make the ultimate decision of how much time the defendant will serve today. Mr. Ellis will have a parameter with a high and a low, but they'll decide where and when that ends. And part of that will be based upon how you've been in prison. When I considered the sentence that I should impose, and I of course thought about this well before today, and I've typed up some notes, and as you can see, I've added a lot to that, crossed out things and thought about as I've listened to counsel, as I listened to the victim's family. But under Utah Code Section 76-3-401, as Mr. Pomeroy pointed out, I need to consider the gravity of the offense, the circumstances of the offense, the number of victims, and the character and rehabilitative needs of you, Mr. Ellis. Clearly, this is as grave of offense as we can see. You have a more grave offense than the murder of somebody. I can never bring the victim back. I can never impose any type of a sentence that would restore Mr. Ellis back to his family. Mr. Rastelli, excuse me, back to his family. The victims are not just as mentioned by the state, Mr. Rastelli, but it's his two children, your niece and nephew, who were present in the home when you shot and killed their father. And of course, these two, your niece and nephew, are now being raised by their uncle and their aunt. They are struggling with their father's loss and the impact that has on them. As Mr. Rastelli pointed out, he just took your niece to their second father-daughter dance. It's to his credit that he's willing to take his niece and step into that role, but he's only stepping in. He can't take over as father. He can only do as best he can. And your niece and nephew are going to grow up knowing that their father was killed by their uncle for no reason. And tragically, your niece and nephew are facing the ramifications of your actions when they go to school, when other students at school bring up what you did. That really, to this court, shows the gravity of your actions, is that they'll never end for these two children. They will, for the rest of their life, have to live with the fact that they don't have a father for no reason other than the selfish actions of you. I recognize you have a minimal criminal record. However, I find your rehabilitative needs to be the extreme. You killed your brother-in-law solely for the convenience of your sister. As I mentioned, he was not a danger or a threat to you, your sister, or any other family members. I consider the extensive planning that went into this crime, including the planting of a knife in your brother-in-law's hand in an effort to confuse or throw off the investigation of your actions. As I mentioned, I think your rehabilitative needs are extreme because this wasn't an action of passion. It wasn't a spur-of-the-moment action. It's something that was coldly plotted out by you, yet something that you knew you shouldn't be doing, as we heard in that transcript today. When I take into account all these factors, I believe consecutive sentences are warranted. Therefore, for murder, the statutory maximum that I can impose by law is 15 years to life, and I impose that. For the obstruction of justice, a second-degree felony, once again, the maximum sentence that I can impose by statute is 1 to 15 years, and I impose that. As for the domestic violence in the presence of a child, there are 2 counts of that, third-degree felonies. The maximum sentence that I can impose for those 2 counts is 0 to 5 years in life. When I consider the circumstances of this case, as detailed in the trial, as I just briefly touched on, and by your victim's mother and his brother, I find that it's warranted to run those 4 counts consecutive to each other. As it pertains to the count of purchase, possession, or transfer of a firearm. I impose the statutory maximum of 0 to 5. However, I allow that to run concurrent. As to the count, possession of a controlled substance, a Class A misdemeanor, the maximum that can be imposed is 364 days. I'm going to give you credit for time served, close that case out, order you to pay a $53 court security fee as required by statute, and send that amount to the Office of State Debt Collection. I'm waiving the fine on that. As it pertains to the fine and the other 5 counts, I'm going to waive them, recognizing that you're going to spend at least 20 years in prison. And I would prefer that any income that you have go towards the restitution that I'm going to be ordering. So I'll waive the fine there, but I will order the mandatory $53 court security fee for each count. I'm going to issue a continuous protective order in this matter, which means you can have no contact directly or indirectly with your niece and nephew, ever. As required, I'm going to give you credit towards the sentence for the time that you served since you were arrested back in July of 2024. The parole board will make that decision as to how much time that will ultimately apply to. And I, of course, order restitution in the amount of $9,700. The record will reflect that that's contained in the pre-sentence report, and that those names will be paid off a little bit at a time, and probably never, to be honest, Mr. and Mrs. Rastelli. That'll be the order of the court. You have 30 days to appeal the sentence that I've imposed today. On an appeal, I would appoint an attorney to represent you at no cost if you qualified and requested the same. Mr. Williams, did you have a question?
I'm sorry for this legalistic, but will you order the restitution joint and several?
Yes, I think that's actually required. We just had a case come down on that. So restitution, of course, will be joint and several. Any other questions, Mr. Williams?
No, thank you, Your Honor.
Mr. Pomeroy, anything from the state?
One moment, please.
Mr. Brown, we have the name, but we'll need the contact information to mail any restitution amounts. If you could provide that privately to Faye. We will. If you don't have that today, then you can just email that to her. When you email it to her, just to make sure that it's not ex parte, just CC Mr. Williams and Mr. Ramos. That's just that we have the name of the parties for restitution, but we need the contact information. So they'll email that to the court if they don't have it today, and they'll just CC that to you, Mr. Williams, just to make sure everything's correct.
Thank you, Your Honor.
Mr. Pomeroy.
Thank you, Your Honor. I don't know there will be any further requests for restitution, but if we could just leave it open for the statutory period in case something comes down.
Any objection, Mr. Williams?
No.
I mean, I think that seems appropriate. There may be counseling for the children. I think that was touched upon at the prior sentencing of Ms. Rastelli. So I'll keep that open pursuant to statute, of course, joint and several as well.
Thank you, Judge.
All right, that'll be the order of the court. Thank you, counsel. We'll be in recess.
All right.
Consecutive sentences, the order of the day. This is our Provo, Utah. Utah man sentenced to consecutive prison terms after a jury found him guilty in the death of his brother-in-law. Kevin Ellis was convicted of murder, obstruction of justice, and domestic violence in the presence of children after he shot and killed Matthew Rastelli on January 12, 2024. Ellis pleaded not guilty at trial and argued that he shot the victim 7 times in self-defense. Rastelli's wife, Catherine Rastelli, is Ellis's sister and testified at trial that she lured her husband into her mother's Utah home so that her brother could kill him. The sibling's mother, Tracy Grist, is scheduled to stand trial for her alleged role in the killing next month. After his conviction, Ellis spoke about the case in a jailhouse phone call with one of his sisters. I still bear so much of the blame for all this, Ellis said in the call, played during his sentencing hearing on last Tuesday. I should have said no. his sister. The same person who planned this is the same person who baked cookies. Ellis. Hmm. And that's wild. She was the one who made me my chocolate chip cookies without chocolate chips. Prosecutor Adam Pomeroy said that while investigators consider Grist to be the ringleader of the plot, the phone call shows that Ellis bears responsibility for the victim's death. I literally warned her, Ellis said on the call. I said, this will change so many lives. You won't even know how many lives it's going to change. Matthew Rostelli's younger brother, Jonathan, delivered a victim impact statement at the hearing, highlighting the youngest victims in the case. Matthew and Catherine Rostelli's two young children, who learned about their uncle's involvement in the case from friends. That's right, Kevin. They know, Jonathan Rostelli told the defendant. They found out at school. Other kids talking about it, saying things no child should ever have to hear about their father, about how you shot him. They came home confused, trying to make sense of it. The victim's mother addressed Ellis directly in court. Your common sense should have kicked in, Diane Roselli said. Your family gave you bad advice and direction instead of thinking for yourself and acting and recognizing, the evil family traits. You did the unthinkable. Shooting my son Matt multiple times as he was running for his life. You unloaded 7 shots into him and savagely killed him as if you were hunting a wild animal. Judge Roger Griffin granted prosecutors' request to sentence Ellis on each count consecutively. You clearly could have backed out and said no and stopped, and it wouldn't have occurred, Griffin said. And you didn't have the courage or the desire to say no. As you heard from the murder charge, Griffin sentenced Ellis to 15 years to life. That will be considered consecutively to the sentence of 1 to 15 years for obstruction and 2 sentences of 0 to 5 years for domestic violence in the presence of a child. The Utah Parole Board will make the ultimate decision on when and if Ellis is released. Whew. Here's what the jail call recognized. It wasn't just background noise. It was the prosecution's emotional anchor. Ellis's admission, however brief, was framed as acknowledgement of wrongdoing, recognition of the moment he could have prevented the crime, evidence of conscious decision making, and the death. And the defense argued that it showed remorse. The prosecution argued that it showed clarity, that Ellis knew exactly what he was doing. Ellis had already been convicted, and the sentencing hearing was the final step. It reviewed the nature of the offense, the impact of the victim, Ellis's criminal history, and the emotional weight of the jail call. For the judge, the reaction they often treat jail calls as windows into a defendant's true mindset. Here, the judge noted the significance of Ellis's words, but emphasized that remorse alone cannot outweigh the harm caused. And as for the sentencing, the court imposes substantial reflecting the seriousness of the crime, the need for accountability, and the limited mitigating value of Ellis's after-the-fact regret. All that to simply say that justice was served in this one. Now we get ready to go to Massachusetts, where a judge denied Lindsay Clancy's request to split the trial into 2 phases. This might be good for guys, because check this out. Massachusetts judge rejected Lindsay Clancy's attempt to split her murder trial into two, which is a ruling that keeps the case on a single emotionally charged track. Here's what happened. Lindsay Clancy, the Dewberry mother accused of killing her 3 children, asked the court to bifurcate her trial. Bifurcate meaning to split the trial in half. Her defense wanted one phase to determine whether she committed the acts, and a second phase to determine whether she was criminally responsible due to severe mental illness and postpartum psychosis. The judge said no. This ruling means the jury will hear all evidence, factual and psychiatric. The ruling means that the jury will hear all the evidence, factual and psychiatric, in one continuous trial, preserving the traditional structure and raising the emotional intensity of what the jurors will have to process. The defense is arguing that combine the two issues, the acts themselves and her mental state would violate her Fifth Amendment rights, force her to present mental health evidence that could be self-incriminating, and confuse jurors by blending factual guilt from psychiatric responsibility. They claimed that a split trial was the only fair way to present an insanity-based offense. The judge rejected that request, finding the following. Massachusetts law does not require bifurcation. Insanity defenses are routinely handled in a single trial. The evidence overlaps too heavily to justify dividing the proceedings, and the defense constitutional argument was not persuasive. The court emphasized that jurors are capable of weighing both factual and mental state evidence together. The prosecutors opposed the split, arguing the same witnesses and evidence would appear in both phases. Bifurcation would be redundant and confusing, and Lindsay Clancy, her insanity defense already allows for psychiatric testimony without the rights in it. They frame the motion as a delay tactic rather than a constitutional necessity. This ruling shapes the entire trial. The jury will hear everything at once: the acts, the timeline, the psychiatric evaluations, the postpartum psychosis claims. The emotional weight will be unbroken, which can influence how the jurors perceive both guilt and responsibility. The case is already one of the most emotionally complex in the country, involving motherhood, mental illness, medical treatment, and unimaginable loss. Keeping the trial unified ensures the story is told in one devastating arc, not two controlled chapters. And like I said, jury hears everything at once. Emotional weight will be unbroken, and the defense loses a key procedural strategy that could have softened the impact of the most disturbing evidence. So now, it's all going to come out in one shot instead of a two-piece. Now we'll see what's the next part of the defense attorney's game plan for Lindsay Clancy. Oh, and by the way, there is an update. There is an update on her case. Accused killer Lindsay Clancy is renewing her request to split her upcoming murder trial in 2 parts, and to that effect, she says she's willing to admit her role in the killings. The 35-year-old is charged with 3 counts of murder and 3 counts of strangulation or suffocation for allegedly killing her 3 young children. Clancy has not pleaded has pleaded not guilty and has indicated she plans to use an insanity defense, arguing that she was in the throes of postpartum psychosis during the incident. Clancy's attorney, Kevin Reddington, had previously asked Judge William Sullivan to bifurcate the trial into two phases, with the first focus on proving that she committed the crime, and the second focused on whether she possessed the ability to form the intent to commit the crime. Sullivan denied the motion, saying that it would be nearly impossible to split the evidence apart and the process would be duplicative. Now Reddington has filed a new motion asking Sullivan to reconsider his ruling. The latest filing argues that the death of the children is not a live issue, and the defendant is willing to stipulate formally in writing to her involvement in the underlying conduct resulting in the death of 3 children. With that understanding, the defendant submits that the only live issue for consideration at trial would be the defendant's state of mind as it relates to the defense of lack of criminal responsibility. Investigators say Clancy used exercise bands to kill her children, ages 3, 5, and 7 months. Let me correct that. Ages 5 years, 3 years, and 7 months. Before jumping out of a second-story window at the family's Dewsbury home. Excuse me. Prosecutors have pointed to evidence that Clancy plotted the children's deaths, going so far as to map out routes to send her husband away from the house on the day of the slayings. But Clancy has maintained that she had no responsibility for her own actions, was hearing voices telling her to kill the children. Prosecutors filed a response opposing the move to bifurcate the trial, saying there is no case law that would support doing so, even in cases in which the defense argues that the evidence supporting a lack of criminal responsibility would be harmful to its defense against the merits of the case. The Commonwealth does not address the defense's offer to stipulate the Clancy's involvement. Clancy's jury trial is scheduled to begin in July, and honestly, I don't see any wiggle room, if you want to put it that way. I don't see any wiggle room for Lindsay Clancy to be able to split that trial in half when the word has it that all the evidence, all the come on, let's get the word out. All the witnesses to this whole thing could and will overlap. So I believe deep down that they're wasting their time. And time wasted is actually on the side of the prosecution here. Next up, a delay. Courtney Clenny's murder trial is delayed until summer. All right, here's a break. Here's a breakdown. If I can catch the video before it Okay, the murder trial of OnlyFans model Courtney Clenny has been permanent, which is extending a case already defined by volatility, conflict narratives, and intense public scrutiny. Here is what happened. A judge has officially delayed the trial of Courtney Clenny, the social media influencer charged with murdering her boyfriend, Christian Obumseli, in their Miami apartment. The trial, originally expected sooner, will now take place this summer, which will give both sides more time to prepare for what is expected to be a highly contested courtroom battle. The delay comes amid disputes over evidence, expert testimony, and the defense's claims of self-defense in a relationship they describe as abusive and chaotic. Here's the breakdown. Courtney Clenny's case suffered another setback on this past Tuesday as her trial was pushed back several months. Clenny, who has been in custody since 2022, is charged with second-degree murder in the stabbing death of her boyfriend, Christian Obumseli. Clenny has pleaded not guilty and has claimed she acted in self-defense when she threw the knife that plunged into Obumseli's chest. Clenny, who was a popular figure on the website OnlyFans prior to her arrest, has claimed that she was the victim of an abusive relationship with Obumseli. The alleged victim's family has filed a wrongful death lawsuit against Clenny, arguing that she was the aggressor throughout the relationship. When Clenny was arrested in Hawaii in August of 2022, her attorney said that she had been there in rehabilitation for substance abuse and post-traumatic stress disorder, PTSD. Clenny's trial was scheduled to start at the end of April, but it was put on hold Wednesday after both the prosecution and defense introduced a joint motion to continue the trial. Prosecutors explained that they had between 15 and 16 depositions scheduled this week, but the people scheduled to appear failed to do so. The people in question are Williams Rule witnesses, meaning prosecutors hope to use them to show a pattern of criminality or Clenny's past wrongdoing. Judge Andrea Wolfson said, "Let me just ask, if we're in the same position next time we come back and these witnesses are just not appearing, I mean, there's going to come a time when it's fish or cut bait, right?" Attorneys from both sides acknowledged that time was of the essence and said they were each working to move quickly to resolve all outstanding issues, including scheduling time for a state's expert to meet with the defendant. "We're working diligently to get it done." That's coming from Clenny's attorney Sabrina Puglisi, telling the court. Wilson agreed to postpone the trial, but warned both parties this really has to be a final continuance. While no specific date was set, the parties said they are hoping to schedule the trial to begin in August. The delay, once again, the court granted additional time due to outstanding forensic analysis. Now, when I say outstanding, meaning missing. Pending expert witness reports, unresolved evidentiary motions, and the volume of digital evidence, including video, messages, and surveillance. Both sides signaled they needed more preparation time before presenting their cases to a jury. The defense argues that Clenny acted in self-defense, claiming Obumseli was the aggressor in a violent, toxic relationship. The defense says that this delay will allow them to finalize psychological evaluations, challenge the state's interpretation of video evidence, and prepare domestic violence experts. They're framing the postponement as necessary for a fair trial. The prosecutors maintain Clenny stabbed Obumseli intentionally, and that the evidence, including elevator footage showing her striking him weeks earlier, contradicts her self-defense narrative. The prosecutors maintain that Clenny stabbed Obumseli intentionally and that the evidence, including elevator footage showing him striking her weeks earlier, contradicts her self-defense narrative. They argue the delay doesn't change the strength of their case. The stakes are high with this one. This trial is poised to be one of the most closely watched of the summer, combining a high-profile defendant, a relationship marked by documented volatility, conflicting portrayals of the victim and the aggressor, and a digital trail that both sides claim supports their version. The delay prolongs the wait for resolution, for the court, for the families, and for a public that has followed every development. This is a case where image, influence, and reality collide. The summer trial date ensures the story will unfold under maximum visibility and with every detail dissected in real time. This is going to be one of those cases where we are going to have to wait just to find out what will occur next. Next up on the docket. Okay, next up. A judge overseeing the so-called pink cocaine manslaughter case lost patience in open court, sharply reprimanding both sides for delays, disorganization, and what he called a lack of professionalism. Here's what's happening. In the manslaughter case involving an Instagram model accused of causing a man's death after a night involving pink cocaine, the judge halted proceedings to scold the attorneys, and his frustration centered on repeated procedural missteps, late filings, and a courtroom atmosphere he said was veering off the rails. Mm. Let's see if I can find this. It's because I believe I have the wrong case. Maybe I don't. Or maybe this is another development. Nope. I did have the right link. Here's the a displeased judge scolded attorneys in court Wednesday, saying she may be forced to babysit future depositions in their case if they can't work together. The issue came up at a status hearing for 25-year-old Macy Lathers, who faces a list of charges after allegedly killing 2 people during a hit and run while high on drugs, with a suspended license. Lathers, who has pleaded not guilty, is accused of running a red light on August 10, 2024, and slamming her Mercedes-Benz sedan into a Suzuki, killing the driver and passenger on the bike. Prosecutors say Lathers tried to flee the scene without rendering aid, but was stopped by bystanders. Police from Video from police body cameras, shows her on the ground screaming and later telling officers that her name was Mercedes and she was from the future. The defendant allegedly told officers that she used pink cocaine, a powdered mix of drugs that can include cocaine, fentanyl, MDMA, and methamphetamine. Lathers was not the topic of conversation at her hearing on Wednesday. Rather, the attorneys took center stage. Prosecutors Sonali Desai filed a motion on Monday accusing defense attorney Martez Gordon of failing to comply with protocol when scheduling depositions. The motion, which Judge Tanya Brinkley noted was 6 pages and single-space, was a formal request for the court to intervene for future depositions. Brinkley said that she had been doing voir dire in a different trial when her judicial assistant pulled her away because of a fiasco at the Lathers deposition. The side maintains that Gordon scheduled a deposition incorrectly and refused to wait for further instructions from the judge. When Brinkley asked Gordon to respond to the accusations, he demurred, saying he had just seen the motion the day before. We thought the scope of today's hearing would be based on the case management or status, Gordon said. During the deposition, the side requested court intervention, Brinkley responded. So when you tell me we are not aware of it, we didn't know. We received it but haven't had an opportunity to review it. It's somewhat disingenuous. Gordon maintained that he had done nothing wrong and wanted to wait until he had a copy of the deposition transcript to defend himself against inaccuracies and allegations made in the side's motion. It's a gross exaggeration of what took place, Gordon said. A clearly frustrated Brinkley encouraged the two sides to work together and warned that if there is any issue during future depositions, the proceeding will need to be suspended and brought to court for a special hearing. If that is necessary, she said, I'm going to be deeply, deeply disappointed in both of you. And I can assure you that whomever I determine to be the proponent of the difficulty, I'm going to impose sanctions. The parties are scheduled to return to court on June 17th for a status hearing. Ooh, boy. Judge is got to be hot at this point. The rebuke became the headline, overshadowing the sensational details of the case itself. Here's the details. According to the court transcript, the judge admonished both prosecution and defense for failing to have evidence ready, arguing over basic procedural issues, wasting the court's time, and creating confusion for the record. She warned that the case was becoming unmanageable due to counsel's conduct. The defendant, an Instagram model, is charged with manslaughter after a man died following a night out involving pink cocaine, a stimulant-based designer drug known for its bright color and party culture branding. Yeah, that auto accident had a lot to do with that. The case has drawn attention because of the influencer angle, the drug's notoriety, and conflicting accounts of what happened that night. The judge's scolding came after yet another dispute between the two sides over admissibility of toxicology, expert witness scheduling, discovering deadlines, and handling of digital evidence. The back and forth had become so frequent that the judge finally intervened. The impact of this reprimand, judges' scoldings aren't just theatrics. They can signal impatience with delay tactics, pressure attorneys to tighten their strategy, foreshadow stricter rulings on future motions, and shape how the jury perceives the professionalism of each side. In a case fueled by sensational details, the judge's frustration adds a new layer of tension. This is one of those moments where the courtroom becomes part of the story. A judge stepping in to restore order tells the audience and the attorneys that the case is bigger than the personalities arguing it. It's about people who died, a defendant whose public persona complicates perception, and a legal process that must stay disciplined despite the noise. And if they can't get it together, that judge is going to get absolute ugly with both prosecution and the defense. Okay. As I get ready to go to the next story on the docket, I want to remind you the definition of madness is doing the same thing over and over and over again, expecting different result. Now that we got that clear, ex-sheriff Sean Mickey Steiners tries to again to remove the judge from his case. Former Sheriff Sean Mickey Steins is once again trying to push the judge off his case, a move that signals strategy, frustration, or both as the legal pressure tightens. Here's what's going down. Sean Mickey Steins, a former sheriff facing criminal charges, has filed yet another motion to remove the presiding judge from his case. This is not his first attempt. It's part of a pattern of challenges aimed at reshaping who controls the courtroom and how the case proceeds. The judge has previously rejected similar efforts, but Steins is pressing forward, arguing that the court cannot be impartial. Okay, here's what we got. We're in Whitesburg, Kentucky. Less than a month after his original request was denied, former Letcher County Sheriff Sean Mickey Steins is fighting to have the judge removed from his case. The 44-year-old Steins is charged with murder in the shooting death of Letcher County Circuit Judge Kevin Mullins, age 54, on September 12, 2024. Steins admitted to gunning down Mullins, who was also his friend, inside the judge's chambers, but has filed documents indicating he plans to rely on a mental health defense. In those filings, Steins claimed he lacked the ability to form the intent to kill when he pulled the trigger. Surveillance videos showed the shooting play out in Mullins' office, with the judge diving beneath a desk in an attempt to escape. Steins previously requested that Judge Christopher Coron recuse himself from the case, arguing that he couldn't be impartial. Steins' defense pointed to a video of September 12, 2024, meeting of the Kentucky Judicial Commission on Mental Health. There, just 7 days before the shooting, Coron and Mullins sat next to each other for the 2-hour gathering. In his order denying the initial request, Coron conceded that the video showed him with the victim but denied any relationship that would cloud his judgment. To be sure, Judge Mullins and I share the legal profession and may, in that regard, be viewed as colleagues. But our nominal, purely professional association is not the degree of relationship which would interfere with my duty to uphold and apply the law and to perform judicial duties fairly and impartially, or suggest an appearance of partiality, Coron wrote. Now, Steins has filed an affidavit with the court saying, in part, "It is my belief that I will not be afforded a fair and impartial trial or pretrial proceedings by Judge Coron and seek the designation of a special judge pursuant to KRS 26A.020. The Kentucky law referenced in the affidavit allows for either party in a case to file an affidavit seeking a new judge if they feel they cannot get a fair trial. Okay, so the Kentucky law referenced in the affidavit allows for either party in a case to file an affidavit seeking a new judge if they feel they cannot get a fair trial. Steins' latest filing also notes that Mullins' wife, now a widow, was in attendance at the meeting. It is my belief that in addition to the meeting shown in the video, there was a companion social or dinner event connected to the meeting, Steins wrote. It is my belief that the trial of this matter will necessarily include evidence regarding the week's events Mullins discussed in the video. As such, it is difficult to believe that Judge Coron's proximity with Mullins such a short time before the events at issue will not affect his judgment in my case. Video of the meeting, which had previously been posted online, is no longer available to view. That kind of sucks because I would have loved to have seen all that. Anyway, the recusal push. Steins claims the judge saying that the judge has shown violence, made rulings that would undermine his defense, and cannot fairly oversee the proceedings. His filings frame the judge as someone whose decisions have consistently favor the prosecution. The judge has already denied earlier recusal motions, stating that there's no evidence of bias. There's no adverse rulings that do not equal. There are adverse rulings that do not equal prejudice, and the court is acting within legal bounds. Judges rarely step aside without clear, documented conflict, and none has been established here. The defense's repeated attempts to remove a judge often signal dissatisfaction with pretrial rulings, an effort to reset the courtroom dynamic, a desire to delay proceedings, or a calculated move to create appeal issues later. Stannis' team appears to be laying groundwork on multiple fronts. Now, the prosecutors argue the motions are baseless and disruptive. They say Stannis is trying to manipulate the process rather than confront the evidence. If the judge were removed, it could delay the case significantly, force a new judge to revisit prior rulings, and shift the term in the entire courtroom. If he's denied again, which is likely, it reinforces the court's stance that Stannis' claim lacks merit. This is a former lawman now fighting the system he once represented, and a defendant trying to change the referee instead of the playbook. A courtroom wrestling not with just evidence, but with power, perception, and control is what this story is about. Sometimes you just get lucky. In this case, Letitia Stout is one of those defendants. She's going to get a new murder trial after an appeals court finds a biased juror. Let's recap for all of you who don't remember this case. Letitia Stout is convicted of murdering her 11-year-old stepson. Now she's getting a second chance in court. An appeals panel ruled the juror's hidden bias tainted the integrity of the trial. The Colorado Court of Appeals has overturned Letitia Stout's murder conviction and ordered a new trial, finding that one of the jurors failed to disclose significant bias during jury selection. Stout had been convicted of killing her stepson Gannon and was serving a life sentence. The appellate judges ruled that the juror's non-disclosure deprived Stout of her constitutional right to an impartial jury, requiring the entire verdict be thrown out. All right, we're going to get ready to go right to the article now. We were in Denver. A woman convicted of killing her 11-year-old stepson and leaving his body under a Florida bridge has won a new trial after an appeals court found a juror was improperly admitted into her first trial. 42-year-old Letitia Stout was sentenced to life in prison without the possibility of parole, plus an additional 13 years after she was convicted of first-degree murder and tampering with evidence in the death of Gannon Stout. At trial, the defendant pleaded not guilty by reason of insanity and argued that she suffered from dissociative identity disorder at the time of the killing. A 12-person jury deliberated for nearly 8 hours over 2 days before delivering the verdict. Now, the Colorado Court of Appeals has ordered Stout's conviction be overturned and she be granted a new trial because of a juror who should not have been allowed to deliberate. Under Colorado law, any juror who is related within the third degree to any deputy district attorney in the elected area is let's see. Now the Colorado Court of Appeals has ordered Stout's conviction be overturned and she be granted a new trial because of a juror who should not have been allowed to deliberate. Under Colorado law, any juror who is related within the third degree to any deputy district attorney in the elected area is ineligible to serve on the panel. During voir dire in Stout's trial, juror M.B. revealed that his son-in-law worked in the El Paso County District Attorney's Office, the same office prosecuting Stouch's case. While Stouch's defense counsel objected to the juror and asked that he be stricken, the trial judge refused. I don't think it's a statutory cause, Judge Gregory Werner said at the time. We conclude the trial court's statement. I don't think it's a statutory cause reflecting the court's mistaken belief that juror MB's implied bias based on his relationship to the prosecutor, as distinct from his actual bias as a result of that relationship, did not trigger mandatory removal under Section 16-10-103, subsection 1, paragraph B. In the appeal, prosecutors didn't dispute that MB was covered by the statute, but argued that there was no need to reverse the conviction because it was unclear whether MB deliberated. But the Court of Appeals disagreed and said their review of the record made it clear that MB did deliberate on the case. Gannon was reported missing on January 27, 2020, when Stouch called 911 to report the child hadn't returned home. But in the coming days and weeks, investigators said she refused to cooperate with detectives and kept changing her story. At trial, prosecutors said that Gannon was murdered on January 27th, with enough evidence that blood stained his mattress, soaked through the carpet, and stained through the concrete below his bed. After the murder, investigators said Stout moved the child's body through the house and then into a Volkswagen Tiguan before dumping him off a highway in Douglas County. When police seized that car, investigators said Stout obtained a Nissan Altima and returned to the area where she dumped the body to remove evidence. Gannon's body was found in a suitcase along the Escambia River Bridge in 2020. The child suffered a fractured skull, a gunshot wound to his lower jaw, 18 sharp force wounds, and what appeared to be defense wounds on his hands. His cause of death was determined to be a gunshot wound with blunt force trauma to the head. Oh boy, oh boy. Now I know a lot of us who follow this trial will likely be the ones to say that Letitia Stout does not even deserve a new trial. But que será. Whatever will be, will be. Here's the details. The juror issue was decisive. The appeals court found that the juror withheld information about personal experiences and opinions that would have disqualified them from serving. The panel ruled that non-disclosure was intentional, not an oversight. That's a key factor in granting a new trial. The state argued the evidence was overwhelming, but the court emphasized that even strong evidence cannot cure a compromised jury. Stouch's conviction and life sentence are now vacated, resetting the case to pretrial status. Prosecutors must now decide whether to retry the case, negotiate a plea, or pursue a different strategy. The ruling does not address guilt or innocence, only the fairness of the original trial. The appeals court said the process was flawed, and in the American system, process matters as much as the outcome. So, Letitia Stout is going to get a new trial. How will it turn out? We'll just have to wait and see. In the meantime, again, we have a lot of people who follow the original trial saying that she doesn't deserve one, especially given the fact of what Letitia is putting that family through for a second time. Next up, Alicia Parch admits to stabbing victim in the heart after a social media feud. I knew it was going to happen one of these days. A social media feud turned deadly, and now Alyssa Parch admits she ended the argument by driving a knife straight through the victim's heart. Alyssa Parch has pleaded guilty to fatally stabbing a woman in the heart after an online dispute escalated into a real-world confrontation. Prosecutors say the feud, fueled by hostile exchanges on social media, culminated in a face-to-face encounter where Parch pulled a knife and delivered a single fatal strike. Her admission in court removes any ambiguity about her role in the killing and sets the stage for sentencing. Here's the breakdown in the article. Maybe we'll get that sentence. Oh yes, a Massachusetts woman was sentenced to prison after pleading guilty and admitting her role in the deadly stabbing and on the Boston Common. 33-year-old Alyssa Parch had faced trial on more serious charges later this month, but instead she chose to plead guilty to the lesser charge of manslaughter in the death of Jasrina Shepard. Parch and Shepard had an ongoing social media feud at the time of the incident and had exchanged a series of messages in which Parch had threatened Shepard and was trying to entice her to fight, prosecutors said. At approximately 11:30 on July 20th, 2023, the two met in person for the very first time. As Shepard walked toward a subway station in the busy downtown area, surveillance video showed Parch approach the victim holding a knife. Prosecutors said that Shepard was unarmed when the two women began to fight. The victim was stabbed multiple times in the face, head, and torso, and Parch fled using the subway system. Judge Mary Ames laid down the rules for spectators in the courtroom before the defendant walked in. This is a hard day. It's a hard day for everybody who's here, Ames said. I know that, and I appreciate that. And I'm thanking you in advance for the respect I know that everyone will show to this court. Ames admonished the gallery not to talk or make any gestures during the proceedings. Prosecutors outlined the basis for the charges, noting that Shepard's death was ruled a homicide caused by sharp force injuries, including a stab wound to the heart. Shepard's family delivered tearful and emotional victim impact statements. I wouldn't wish this on anyone, the victim's brother Christian Gonzalez said. I don't know how I'm going to recover from this. Shepard's mother broke down in tears on the witness stand as she tried to speak, while clutching a poster board with a photo of her dead daughter. Ames took time to speak to each person who delivered an impact statement expressing her condolences. I don't have the power to give you what you would really want, Ames said as he handed down the sentence, because I can't bring your beloved sister, daughter, cousin, and friend back. My hope for you is that at some point in your lives that you may be able to find peace. Ames sentenced Parch to 15 to 20 years in prison in line with the maximum penalty and the prosecutor's recommendation. The stabbing was intentional. According to prosecutors, Parch admitted she aimed for the victim's chest and struck directly in her heart. The conflict began online, with investigators tracing the escalation to a series of hostile posts and messages exchanged between the two women. The confrontation turned physical quickly, and witnesses told police the victim was unarmed when Parch attacked. Parch's plea avoids a full trial, no shock, but it also locks in the state's version of events, including the deliberate nature of the stabbing. Sentencing is expected to be significant, given the admitted intent and the fatal outcome. Prosecutors emphasize the senselessness of the killing, noting that a digital argument spiraled into reversible violence. The core truth is stark. A social media feud became a homicide, and the defendant now owns that choice in open court. So she took a lesser charge and is just serving 15 to 20 years. Now that I'm thinking about that and knowing my hatred for plea deals, no, that's not justice to me. That's not justice to me at all. And finally, the Mississippi Supreme Court is agreeing to hear Carly Gregg's murder appeal. Mississippi's highest court is stepping in. The state Supreme Court will hear Carly Gregg's appeal, giving the convicted murderer a rare shot at overturning her case. Here's what we know. Mississippi Supreme Court has agreed to review the murder conviction of Carly Gregg, who was found guilty in the killing of her mother and her stepfather. Gregg has long argued that her trial was marred by legal errors, including improper evidence and flawed jury instructions. By granting review, the state's highest court signaled that at least one of her claims raises a substantial legal question worth examining. This is not a reversal, it's an opportunity. The Supreme Court is. Wait. Before I dig into all the details, let's go to the article first. Mississippi's highest court has agreed to hear an appeal from a teenager convicted of killing her mother and shooting her stepfather. Carly Gregg, now 16 years old, was 14 when she was convicted of murder, attempted murder, and tampering with evidence after shooting her mother and stepfather and inviting a friend to see their bodies. At trial, Gregg pleaded not guilty by reason of insanity and argued she had suffered from mental illness at the time of the shooting. Gregg filed her appeal with the Mississippi Supreme Court in September, arguing multiple failures at her trial that she believes merit her conviction being tossed and a new trial ordered. On Thursday, the state's highest court agreed to hear the appeal and scheduled oral arguments for May 27th. In a reply brief filed earlier this year, Gregg maintains that she was compelled to sit for psychiatric examinations by state experts before her team had formally announced their intention to pursue an insanity defense. Gregg's defense argued the exam she was forced to undergo violated her Fifth and Sixth Amendment rights. Accelerating evaluations and discovery to preserve a trial date undermines due process and fundamental fairness, the brief states. Gregg's defense has emphasized that the accelerated pace at which they felt were forced to move to comply with a trial court that refused to waver on a set trial date. The trial judge did not say that continuances are disfavored, discouraged, or rarely granted. He stated without qualification that this court does not continue cases, and did so while announcing a firm September trial setting and admonishing counsel to proceed accordingly. Gregg's appellate attorney wrote this. Issues of timing were a focus pre-trial as Judge Dewey K. Arthur weighed sanctions after the defense missed several discovery deadlines. Gregg's appeal also focuses on what it calls inadmissible testimony from the state's expert, Rebecca Kirk. Gregg objects not to the substance of Kirk's analysis, but rather to the fact that while she was on the stand, Kirk gave a summary of the novel Crime and Punishment, which was mentioned in Gregg's treatment notes. The detailed narration of the novel's plot added no clinical, therapeutic, or diagnostic value, Gregg's attorneys argue. The state did not contend, and the record does not reflect that Carly identified with the protagonist, discussed the book's moral philosophy, or connected its themes to her own conduct. Instead, the state selected one of the most infamous novels in Western literature about murder and justification of violence and placed its storyline before the jury. This was not contextual clarification, it was narrative substitution designed to shape the jury's perception of Carly's mental state through association with a fictional character. The appeal also notes perceived errors in Greg's sentencing. Her attorneys feel the jury was given incorrect instructions and should have been told that for juveniles, parole eligibility is the default, rather than life without parole. Several letters have been submitted to the court as amicus briefs arguing on Greg's behalf on various issues, including one from a concerned citizen from Poland currently residing in Ireland. Each side will have 30 minutes to present oral arguments when they appear before the court in May. So back to those details. This is not a reversal, it's an opportunity. The Supreme Court has simply agreed to hear the appeal, not rule on it yet. Carly Gregg's attorneys argued key evidence was mishandled, including statements they say should have been suppressed and forensic conclusions they claim were overstated. The appeal also challenges jury instructions, alleging they misrepresented the legal standard for intent. The state maintains the conviction was sound, pointing to witness testimony and physical evidence that supported the jury's verdict. The Supreme Court's decision to take the case is significant because most appeals are denied without review. If Carly Gregg wins this, the court could order a new trial, modify the conviction, or send the case back for further proceedings. The takeaway, the conviction isn't overturned, but the door is now open. And in appellate law, that door rarely opens unless something in the record demands a closer look. And here's what we know. Tonight's case has reminded us of something simple but unshakable. The justice system is always in motion, even when the people inside it try to slow it down, steer it sideways, or rewrite the story after the fact. We saw defendants challenging judges. We saw attorneys clashing in courtrooms. We saw delays, denials, apologies, and admissions. And through it all, the law kept moving forward, always forward. Because at the end of the day, the process doesn't bend to pressure. It doesn't pause for personality. It keeps going, case by case, ruling by ruling, and truth by truth. All right, guys, that's the final word. A clear look back at the stories that carried us through the week and the lessons we take with us. Thanks for joining me. Stay safe, stay grounded, and stay informed. I'll be back. Well, it's 1:23 in the morning here in Salem, Oregon. I'll be back later this evening with Saturday night's main event, The Dirty Dozen. I look forward to joining you for that one. So until then, I'm Ernest Bethea, the Last Outlaw, and this is Bethea'S Byte, and it's reloaded. Good night, everybody. Thank you so much for joining me here at the drama-free true crime destination. Please be sure to follow Bethea'S Byte Reloaded all over social media and support the channel through PayPal and Cash App. You can get your true crime news right here with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.